A cyclist who crashed into a pedestrian at high speed while she was crossing the road and who then later died of her injuries will not face any charges following the collision, for a number of reasons, one of which being that speed limits do not apply to cyclists, because cycles, for the most part, do not have a speedometer and they can't check how fast they are travelling. Now, indeed, many do have some sort of GPS device that gives them an indication of how fast they're travelling, but they are not a mechanically propelled vehicle, they don't have an engine, and thus the speed limits do not apply to cyclists. But one of my viewers also kindly emailed me to ask the question as to, well, why could not the cyclist be charged with careless cycling or dangerous cycling, just as it applies to vehicles? And indeed, they could. And in fact, there's a third offence, which is wanton and furious cycling, which also requires that an injury is sustained by another person. I'll come back to that in a moment. But first of all, if you're new to me, I'm Daniel Shensmith, a barrister of England and Wales. If you find my content useful, please do hit the subscribe button. I find a lot of you don't, about 70% of you don't, and I'd be really grateful if you did. So if you want to read more about this story, I will link this article from Road CC in the description below. Hilda Griffiths sadly died, who was aged 81, 2 months after the collision, after suffering several broken bones and a bleed on the brain. Now, the time between the collision and her sad death also meant that this collision is recorded as one causing serious injury rather than a fatality, because it was more than 30 days in the national statistics. Now, whether you agree with that or not is entirely another question, but the statistics are what they are. I don't make the rules. But as to whether or not the speed limits apply to cyclists, indeed they don't. They apply to mechanically propelled vehicles because they are usually fitted with speedometers and they are mechanically propelled. But the very next question people usually ask, so I'll take a small tangent for that, is about electric bikes. Do these have to comply with speed limit requirements? Now, that depends on various things, which is outlined on this link, which I'll also link in the description below, being that it is an electrically assisted pedal cycle if it meets these criteria. And if it does, you do not need a license to ride one, it doesn't need to be registered, it doesn't need to be taxed, and it doesn't need to be insured. Although, as a lawyer, I would tell you that that's probably a very good idea. At least try and get it covered on your house insurance if they are willing to do so. It will qualify as an EAPC, meaning that it's treated as a normal cycle, pedal cycle, and you don't have to comply with the normal speed limits. If the motor has a maximum power output of 250 watts, it cannot be propelled more than 15.5 miles an hour, and it must also show the power output, the manufacturer of the motor, the battery voltage, and the maximum speed of the bike. If it complies with all of those things, it's treated as a normal pedal bike. You can ride it on any cycle path or anywhere else that normal bikes are allowed. As for any other kind of electric bike, those that you see, and I've mentioned in some of my other videos, that are just being used and abused on the roads because they exceed all of these, and doubtless many of them ride them without insurance and tax and everything else. If the electric bike exceeds any of those power or speed limitations, then it is treated as a motorcycle or moped, needs to be registered, needs to be taxed, you need a license, and you must, of course, abide by all of the road requirements. But now coming back to ordinary cycles and relevant offences, some of which are contained within the Road Traffic Act 1988. Section 28 is for dangerous cycling. The wording is similar to that for drivers, only in relation to cycling. A person who rides a cycle on a road dangerously is guilty of an offence. And dangerously means if and only if the way they ride falls far below what would be expected of a competent and careful cyclist. And it would be obvious to a competent and careful cyclist that riding in that way would be dangerous. Section 29 is for careless or inconsiderate cycling, and that is exactly as it sounds, cycling on a road without due care and attention or without reasonable consideration for other persons using the road would be guilty of an offence. So again, that is similar to other drivers, but it applies to cyclists. Interestingly, Section 30 also covers someone who is unfit to cycle through the influence of drink or drugs. So you can't get drunk, for example, and then ride home, because if you were to crash into somebody whilst drunk, you could be charged with being cycling whilst unfit under the influence of drink or drugs. And then there's the other offence that I mentioned earlier, which is wanton and furious cycling under Section 35 of the Offences Against the Person Act 1861. So now coming back to the question as to why was this cyclist not charged with anything following this collision? collision, even though he was riding at an estimated 25 to 29 miles per hour. Well, there's a number of questions to unpack here. First of all, as to whether or not the speed limits apply to cyclists. Now, speed limits only apply to mechanically propelled vehicles, and that's because they usually have a speedometer attached and they are mechanically propelled and therefore have the speed limits applied to them. As I said, electric bikes fall outside of that remit if their power or speed output is beyond those limits. But then as to careless and or dangerous cycling, they would need to be proved to the same criminal standard as any other road traffic offence. And it would need to be established by any prosecution. And it would need to be established that either, in the case of careless or inconsiderate cycling, that the cyclist was cycling without due care and attention or without reasonable consideration. But the inquest heard that he was given almost no reaction time because, according to the article, she stepped out into the road without looking, gave him zero reaction time, and therefore the collision occurred. But that in and of itself doesn't prove that the cyclist was riding without due care and attention or without reasonable consideration for other persons using the road. And whilst the argument could be made that he was exceeding the set speed limit for other vehicles on the road, again, because those speed limits do not strictly apply to cycles, that would raise a reasonable doubt and thus a prosecution is likely to fail. Likewise, and with dangerous cycling, that is where the standard falls far below, and it would be obvious to a competent and careful cyclist that the standard fell far below and that it would be dangerous. And therefore, dangerous cycling is highly unlikely to apply here either. And even for driving, dangerous driving is usually reserved for the most serious examples. So dangerous cycling is just not likely to apply here at all. As I say, there is an argument for careless or inconsiderate cycling, but given that the speed limits don't apply to cyclists, given that they are not mechanically propelled, there is no speedometer, they just don't apply, and therefore that is not conclusive proof that the cyclist was riding without due care and attention or without reasonable consideration for other road users. And given that there will be no underlying base offence, it's just not possible to take that any further. For example, manslaughter. Because if there is an underlying dangerous act, which needs to be a very dangerous act or an offence, that can then underpin a charge of manslaughter as the base offence. Much like we discussed in the Ariel Gray case just recently, where the court had proceeded on the assumption that this was either dangerous or an offence, but failed to prove the base offence, and thus the Court of Appeal quashed the conviction for manslaughter. And so likewise here for this cyclist, without any base offence, it cannot go any further, and it cannot, for example, be linked to manslaughter. And so accordingly, and taking everything into consideration, Assistant Coroner Harkin, in conclusion, recorded this as an accidental cycling collision death, and no charges were brought against the cyclist in this incident. Although it has to be said that cyclists are on occasion charged with offences and even imprisoned as a result of collisions. For example, Road CC again writes about such an incident in August 2017, where a cyclist was sentenced to 18-month detention at a youth offenders facility after being convicted by a jury of causing bodily harm by wanton and furious driving of a fixed-wheel bike that had no front brakes, which then was connected with the death of Kim Briggs, into whom he crashed as she was crossing London's Old Street. So I hope this serves to answer some of the questions. I thank my viewer for sending the story to me to give you some of my views. And again, it raises the debate. There are differing opinions as to whether or not cyclists should have to comply with the speed limits. They certainly have to comply with all sorts of other road regulations, and indeed, they can be charged with careless or dangerous cycling, or, in the event of an injury, wanton and furious driving of a pedal cycle, because it's any other vehicle. So I hope that's useful. Please do remember to like the video and subscribe on the way out. I thank you for watching, and I'll see you next time.